Well, my name is John Weaver. I'm a lawyer in the Knoxville Bar. I work with K.O. Hurston. We're with the Hurston Law Group, and we are a family law firm. That's all we do is family law. So we sort of eat, breathe, and live this stuff. I've come today, I'm just going to jump right into my presentation. I'm doing our first special topic. It is, what is income for child support purposes? Well, it's not as simple as you might think. We all know about the definition of gross income that you'll find in the child support guidelines. However, within that definition, there's room for debate about what might constitute income. And as a practitioner, you're going to want to know about those areas where the courts have ruled on something seemingly as straightforward as determining gross income. Determining income for child support purposes. Now, if your practice deals with family law, this is going to come up fairly often. So how do we determine income? It would seem pretty straightforward. You take your income figures from your party's tax returns, divide that number by 12, plug that into your handy state-supplied worksheet, and bam, you've got your income. But what if we're leaving money on the table? Let's take a look at the guidelines. Tennessee's child support guidelines provide that gross income shall be determined in the process of setting the presumptive child support order and shall include all income from any source. They even go so far as to provide us with a list of 21 possible sources of income. Now, I've put the emphasis on the not limited to part to remind us that this list is not exhaustive. There are plenty of ways to get creative. Let's take a look at our list. It's a lot of stuff. So I've broken down our list of possible sources of income because it's fairly extensive. So this is slightly simplified. Well, you see on the left, we've got sources that you would expect to find. We've got the things you'd find on a W-2, like wages and salaries and commissions. In the middle, you'll see some of our unearned income sources, things like interest, dividends, annuities. But you also see some one-time sources of income like capital gains, and we're going to talk about that later. And finally, the right column, you're going to see things like Social Security disability, retirement benefits, workers' compensation benefits, those sort of things. But you'll also see some positive sources like gifts and prizes, or some of those really rare things like lotto winnings. And then finally, we have alimony. And if you'll note, I've put an asterisk beside alimony because alimony or maintenance received from persons other than parties to the proceedings or before the tribunal. So that sort of delineates what type of alimony we have in the list. However, that last slide said, if you'll remember, that the list is not exhaustive. So is there room for alimony from a party to a proceeding? Well, perhaps there is. The court has addressed that. So we're going to move through some cases which will show us how courts have been treating some of these different types of income. First, we're going to start with some earned income cases. We'll look at how courts treat income that's not regular. We'll look at speculative income, and then we're going to look at fluctuating income. And there's been some controversy on how to treat all of those things. Next, we're going to look at retirement and Social Security cases. And then finally, we're going to consider some cases dealing with some one-time sources of income. Our first case is going to focus on wages. And the court tells us that we have to consider all sources of income, including self-employment compensation. And we're going to see that in the next case. This is Milam v. Milam. And this is a case where father was receiving income from work outside of his regular job, or in his case, outside of his regular severance package. Well, and the facts of this case were that we had, of course, divorced parties, and father had lost his job. He took home a large severance package, but he files to modify based on the fact that his severance package is lower than his income, or his previous income. So his income has been decreased. Well, at the same time, father begins consulting on the side. He's also got a couple of unpaid vacation days, and by a couple I mean he was paid about $8,000 for unused vacation days. Well, the trial court looks at it, and they find that father's income would be calculated at the level of his severance pay. This meant a very big reduction in his child support. He went from about $4,500 to about $1,900. Well, the trial court didn't consider any other sources of income. Well, of course, mom appeals. Well, the Court of Appeals looks at the trial court's findings, and those trial court's findings showed that the court had only considered the severance pay when calculating father's income. There were no facts or findings concerning the determination of the amount. So the record showed us that Father had earned nearly $30,000 from consulting. He'd also earned about $8,000 for his unused vacation days. So the Court of Appeals says, wait up. What about the evidence of these other sources of income? Why aren't there any findings concerning how you calculated Father's income? So the court looks at Father's testimony, sees that $30,000 in consulting fees and that $8,000 for vacation days, and so they vacate and remand it to the trial court because the trial court failed to consider all the sources of income. I should note here that this court did not consider the fact that Father was self-employed when they added that consulting work in. And this is something you're going to want to consider if you do have a self-employed client like Father who's doing his consulting business. When you're representing a self-employed client, remember that the guidelines provide you with some adjustments that may lower gross income. We've got deductions like FICA, Medicare, and Social Security contributions. And these deductions may vary based on the amount of withholding, of course. Also, don't forget about self-employment taxes. The guidelines allow you to deduct self-employment tax paid up to about 1/2 of the amounts due in a year. So if you've got a case where the court says that you must include self-employment wages and you've got the applicable deductions to those wages, don't forget about these deductions. Let's turn to a case where income outside of a job is deemed to be too speculative to be included as income. Now this case is going to tackle the question of reliability of income. And here the court considers how income can be too speculative to be reliable. Now the facts in this case were we had a party that filed for divorce in 2009, and at that point in time they had 2 minor children. Father was earning nearly $50,000 per month. Mother was a stay-at-home mom. She had no income. This was a long marriage, mind you. And when the marital assets were divided, of course they were divided equally. However, Mother receives an additional 28% of the estate as alimony and solido. And that's important because inside of that portion of the estate, she got all these rental houses. And these houses are actively being rented, and therefore they're generating income. Well, the trial court finds that the rental houses are earning approximately $4,000 a month. And based on the testimony, after expenses, the court finds that the cash flow would be roughly about $30,000 a year. But this income, however, was not included in wife's gross income because it was too speculative. It was too speculative because the uncertainties of the expenditures required to maintain and manage properties when Mother was going to have to maintain employment herself and be the primary residential parent. Well, essentially the court says here that just because Mother has not historically been in the business of renting properties, she can't expect to receive income on a normal basis from these properties. So the trial court calculates Dad's income at $50,000 a month and Mother's at 0. They don't impute her any income. Well, they both appeal on a variety of issues, but we're going to look at husband's appeal here because he's considering Mother's income. Well, the Court of Appeals recognizes the fact that these houses have historically earned about $30,000 a year. However, the court says that courts setting child support ordinarily look not so much to the source of income as they look to the dependability of its continued receipt. And to support this, the court falls back on the ability to revise. Should mom prove to earn money from the rental properties, then the child support provision in the parenting plan is always subject to revision. So our rule to take away here is that speculative income is not included as gross income for child support purposes. I think this would be a good case to cite if you're advocating against the inclusion of outside income. And this is another speculative income case. This time we're looking at sporadic, one-time bonuses. And if we check the guidelines, we'll see that bonuses are included. Or are they? Well, here we had Father working as a defense contractor, and his job entitles him to periodic performance-based bonuses. Well, at the time of the filing, Father had only received 3 such bonuses. For instance, he had received a one-time signing bonus and a couple of other performance bonuses while he was at this job. Well, the trial court declines to include the bonuses in Father's salary, saying that they were, again, too speculative. Well, the trial court, though, requires Father to immediately notify Mother of any bonuses that he receives. And that makes me ask, was the trial court setting Mother up for a motion to modify? I think they were. Well, the trial court also imputes some income to Mom, despite the fact that she's unemployed, and we get an appeal. So we go to the Court of Appeals. Well, the court acknowledges that the guidelines include bonuses as gross income in the plain language. The court agrees with the trial court, though, that because these bonuses were not guaranteed and that they were too few in number, that they were too speculative at this time for inclusion as income. So the question that makes me ask is, when are bonuses not speculative? What are we looking at? Annual holiday bonuses? A track record of bonuses? How many bonuses? Well, unfortunately, the court doesn't tell us. But in this case, 3 bonuses was not enough. And I think here the court seems to signal that if father accrues a history of bonuses, then maybe mother may seek to revise. So the takeaway from this case is, if you have one-time bonuses, then you have an argument that they shouldn't be included. The next case that we're going to look at considers income that is reliably unpredictable. And here we have a fluctuating income case. I'm sure if you've practiced any family law, you've come across this before. This is an averaging of income case where father's income fluctuates from year to year. And the question was how to account for father's income when it fluctuated from year to year. Well, you might want to pay attention that the child support here was initially set without a presumption of correctness. So this is a recalculation. That's the kind of case you're going to see this in. Well, mother suggested that the court should calculate the income for one year, and this year it was 2009, by the 3 previous years' income. And then for 2010, she suggests to the court that the court should average the 4 previous years' income. So we're going back to 2006, which makes me think that maybe 2005 was a bad year for Dad. Well, the court looks at this and they choose to calculate each of those years' income based on the previous 4 years. So they average the previous 4 years for 2009 and the previous 4 years for 2010. Well, mother doesn't like this, so she appeals. Well, the Court of Appeals looks at it and notes that the child support guidelines do not establish how the trial court is supposed to calculate fluctuating income. That being the case, the trial courts are left to determine on a case-by-case basis the best way to average fluctuating income. And here we had a court that decided on an even number of years for both calculations. Well, lacking an abuse of discretion, mother could not show legal support for her method, so the trial court's method was upheld. I think what we should remember from this case is that averaging fluctuating income is within the trial court's discretion. So, if you can supply your trial court judge with a reasonable method for them to calculate or average out that income, then you may be able to sway them. When you handle child support cases, you know that fluctuating income is common. So maybe the natural question is, when anticipating that there's going to be fluctuating income, can we craft a provision that will automatically adjust child support? Seems like a good idea. Well, our next case is going to address just that question. Well, again, this is another fluctuating income case, and this time it was due to bonuses that father received. Well, these folks got crafty. Well, they incorporated an auto child support adjustment provision into their parenting plan. Well, here we had one child that had resulted from the marriage. We had father's job paying overtime and bonuses, and those bonuses caused his income to fluctuate from year to year. Well, the original decree ordered that father was supposed to pay a sum certain plus 21% of the net sum of his overtime, bonuses, profit sharing, incentive sharing programs. He was supposed to provide mother with a quarterly statement so she could keep tabs. Well, as you can imagine, that's where the trouble came. Well, down the line, the court modifies father's child support obligation by averaging his income over several years. Well, at the same time, they apply this 21% provision. So because of this, he's ordered to pay a pretty large amount of arrearage. Well, as you can imagine, father appeals, saying, hey, wait a minute, we're double counting here. If you're averaging my income and then adding in this, you're double dipping into my income. Well, the Court of Appeals looks at it, and the Court of Appeals says that they will not enforce a provision that allows child support payments to fluctuate. The court says that the statute requires child support payments to be for a definite amount paid in installments, not a fluctuating amount. The court notes that courts generally average an individual's income over as many years or as long a time period as circumstances will permit. And child support guidelines expressly provide for this. The most appropriate way of averaging fluctuating income is within the discretion of the court on a case-by-case basis. So the important thing to take home here is that child support exists for the future support of the child by fixing some definite amount to be paid in installments. So if you get that client that says, my future ex-husband makes all these overtime bonuses and I have no idea what they're going to be. Can we put in a percentage provision? The answer is no. This court will not uphold it. In other words, you can't set up a bonus provision that fixes child support fluctuations. So let's recap. Thus far, we've looked at variable sources of employment, of income, and we've looked at fluctuating income and speculative income. And let's move into something a little more concrete. Let's move into benefits and retirement. And here we're going to look at two specific kinds of federal benefits. We're going to look at Social Security Title II retirement benefits. Those are those that you get from disability or old age. And we're going to look at veterans benefits, and they operate very similarly. The guidelines provide us a formula for dealing with these types of benefits when calculating gross income for child support. And these benefits can be received, remember, by either the parent or the child on the parent's account. Well, when the parent receives the benefit, it's counted as income. That makes sense. When the child receives the benefit, it still becomes part of the support calculation, and we'll see how that works a little bit later. When the child receives the benefit on the obligor's account, this is the obligor parent, inevitably we have two situations that arise. The first of those situations is when the child support obligation is greater than the benefit. Well, in those cases, the benefit paid to the child is subtracted from the obligation. The obligor will still owe the remainder of the obligation. Our second situation is the exact opposite, when the child support obligation is less than the benefit. Well, in that case, the child support obligation is satisfied by the benefit, but any benefit remainder is retained by the caretaker for the child. And our guidelines define the caretaker as the primary residential parent. They keep those funds for the child. Our first case is going to instruct us on how to calculate benefits for determining child support. Now here we're going to look at a case where the child is receiving a Social Security benefit directly. And the court walks us through the process of incorporating that into child support. Well, here we had father reaching retirement age, and he begins drawing Social Security. The child also begins receiving a Social Security benefit directly on his account. Well, those payments are going directly to the child, remember. Well, father petitions the trial court to offset his child support by the amount received from Social Security by the child. Well, surprisingly, the trial court refuses. And their reasoning for this is that the Social Security Administration should figure out who the beneficiary of father's benefits are and what those benefits amounts will be. A little quirky if you ask me, and that's what father thought as well. So he appealed to the Supreme Court. The Supreme Court looks at it and they say, the long-standing policy is that Social Security benefits are not a gift from the government, they're earned income. The guidelines do not permit the court to disregard a Social Security check received by the child if that check is derived from the obligor parent's account. And the guidelines specifically deal with this question, stating that benefits shall be included as income to the parent, so it goes as income to the parent on whose account the child's benefit is drawn. Then they are applied against the child support obligation. And you'll find that right there. Well, just to recap how this works. First, the amount received must be added to the obligor parent's gross income. So on this side, it's added in, and then it must be subtracted from the child support obligation, dollar for dollar. Some states do that differently. In Tennessee, we do that dollar for dollar. So that's how the court tells us to calculate that income. It gets factored into both sides of the equation. Well, let's move from federal benefits to retirement saved and retirement awarded as property. Our next case is going to look at withdrawals from retirement accounts and how that counts as income. Well, our facts here, we had it was a post-divorce petition for modification. In the divorce, father was awarded his retirement accounts in the MDA as property, and that's the key to this case. Later, father depletes those accounts to pay his taxes. Well, mother sees this and thinks, well, he's getting income from this retirement account, cash outs. Well, the trial court declines to include the withdrawals from retirement accounts as income because they were part of the property division. Well, mother appeals. She asserts that the guidelines include all income from the retirement accounts. Well, the Court of Appeals looks at it, and the court affirms the trial court's decision that the retirement accounts have been awarded as property. They say that assets distributed as marital property shall not be considered income for child support purposes, except to the extent that they will create additional income after they are divided. This tends to arise in the context of capital gains as well, and we're going to see that a little bit later. Well, in this case, the withdrawals from the retirement accounts will only be considered income to the extent that they represent an appreciation in value of those accounts since the divorce. Absent a showing of appreciation in value, you don't have income. It's already been awarded as property. So if you find yourself representing someone with a retirement account, you're going to want to point to this case to show that the only amount to be considered is that appreciation in value after the divorce. Absent that showing, no income. So what if you don't actually withdraw money from the account? What if you just roll it over? Well, that's going to be the focus of our next case. And this case is a retirement rollover case. And here we had father leaving his job to start his own construction company. Well, he retains a pension from his previous employment, which he then rolls over into a profit-sharing plan to capitalize his new business. Now, interestingly, the only trustees of this plan are he and his new wife. Well, the money that's put into the plan is used to purchase stock in the new company, and thus the company is capitalized. Well, the trial court looks at it and finds that the money rolled over is not income because it was used to capitalize a business. He doesn't receive any personal benefit from it. Well, mother appeals, it goes to the Court of Appeals, and the court affirms the trial court's ruling. They say that controlling law is that amounts gained from retirement, pension, trust, or even one-time capital gains are included in gross income. However, that would only be the case if father had taken a payout, or at least a portion of that, which wasn't awarded this property, could have counted as gross income. However, this money was simply rolled over. He doesn't personally receive any money from it. So until he does actually receive money from it as his personal income, we're not going to count it as gross income. I think it's worth noting here that there are cases out there, and a couple of recent cases, that recognize the potential for a majority shareholder or sole proprietor like we have here to manipulate income to avoid paying child support. Let's look at a payout case. This next case is going to consider cashing in on stocks or a one-time payout. I think what the court called it here was a capital gain. So unlike the previous case, here our poor client has received the payout. This was a capital gains income case that was considered by the Supreme Court. So that's the first one of these that I get to. Well, here we had parties that divorced after a long marriage, but before the marriage, father had stock in a business. Well, that was awarded to him as his separate property. Well, after they get divorced, later on down the line, father sells his stocks to his sister and he sells them to her for $687,000. He gets $100,000 up front, and then the balance is paid in monthly installments. Well, mom sees all this cash, and she files a petition to modify, claiming that she was entitled to an increase in child support as a result of the income realized by father from his sale of stock. Well, the trial court denies mother's petition to modify child support. They say that one-time capital gains should not be considered in calculating father's gross income. Well, she appeals. The Court of Appeals holds that there's no legal basis for an isolated capital gain rule. So they reverse the trial court. Well, they petition it up to the Supreme Court. And the court notes that the appellate decisions up until this point are in conflict. They say that the child support guidelines do not exempt isolated capital gains from inclusion as gross income. And they analogize this to the inclusion of things like bonuses, gifts, severance pay, and prizes, all of which are typically non-reoccurring. Well, this is kind of interesting in light of those Court of Appeals decisions that we saw earlier, which actually come after this Supreme Court decision. We were told earlier that those speculative sources can't be included, but here we have the Supreme Court saying the exact opposite. The Supreme Court holds that all capital gains, including isolated transactions, shall be considered in calculating gross income. And their reasoning for this is because it allows a child to enjoy the higher standard of living that the parent enjoys from realizing this capital gain. Now, it's worth noting here that the Supreme Court's only including that part of capital gains that represents an appreciation over the amount awarded in the divorce settlement. So, we have to ask, how do we reconcile this with the other rulings that a bonus is too speculative? This would seem to mean that even a one-time bonus should not be included as income, or should be included as income. Well, if you are arguing for one-time sources of income, to include those in your gross income, this would be your case. If not, you'd want to cite those earlier Court of Appeals decisions that I showed you. Let's look at another one-time gain case. This one's one of my favorites. We were just down in Memphis, and these parties are Memphis parties. We've got a case here where mother wants to include father's gambling wins. And father says, hey, wait a minute, sometimes you come on a good run of bad luck. Well, our Memphis parties, so we're close to Tunica. And mind you, father owns a trucking company, so he's able to travel there quite a bit. So he engages in some pretty extensive gambling. Well, this goes before a juvenile court referee. We had never married parties here. The juvenile court referee does not consider the gambling losses in the calculation of income, only the winnings. The referee even says something pretty interesting. Says, how father spends his money in Tunica, Mississippi is like how people come in here and say, well, I pay rent and I pay this and I pay that, and that's just how father chooses to spend his money. That's his choice. So they dismiss the petition to rehear on the issue. Well, it goes to the Court of Appeals. And the court goes through a pretty extensive analysis of the findings of other states and federal tax guidelines because, surprisingly enough, this was a case of first impression in Tennessee. They look at one Arkansas case, and that case holds that the losses can be deducted from the winnings up to the amount of the winnings, meaning that father can't go off and gamble away his child support obligations. So if he wins $50, they will subtract up to $50, not $51. Well, the Court of Appeals is persuaded by this Arkansas decision. They adopt it. So this is the Tennessee rule now. And this is the rule you want to cite if you have a gambling client. Gambling winnings are included in income, but gambling winnings minus gambling losses equals income. Well, further, the court reiterates its previous holding that non-wage earnings like lottery earnings, judgments, and etc. can be included as gross income, but they re-emphasize, sort of against what the Supreme Court just said, that we don't look so much to the source of the income as to the dependability of its continued receipt. So we've got that dependability question again. How does that square with the Supreme Court's earlier ruling that one-time gains are always included? I don't think it does. So we've got a little controversy there. If you want to include one-time gain, this may be your case, but it's also including the one-time losses. So thus far we've considered sources of income that were included in the list of possible sources of income. This last case I want to look at is alimony. And you may be thinking, I know I saw alimony on this list. Well, there's some controversy over what type of alimony you can consider. And let's look at the alimony case. Well, here we have a case where father is seeking to include the alimony that he's paying to mother in her gross income. Well, here we've got dad, he's a nuclear engineer, and mom is also an engineer, but she's been staying home to raise the children. So dad's making about $619,000 a month. Mom's income is imputed to her at $72,000. Well, the trial court looks at takes the child support worksheet and includes the alimony that dad is paying to mom in the income figures. And it's worth noting here that mom's receiving about $6,600 a month in alimony, or about $80,000 a year. Well, husband relies on an ancient case that was tried before the new guidelines were put into place. Well, at that point in time, the guidelines read that gross income shall include all income from any source, including alimony or maintenance. Well, the trial court finds that argument to be persuasive, and they find that alimony should be included in mother's income. It's worth noting that our new guidelines say that gross income includes alimony from persons other than parties to the proceeding or before the tribunal. Well, the Court of Appeals holds that the plain language of the guidelines expressly excludes alimony payments paid by a party to the proceedings. They note that dad's case was tried before 1995, long before the definition in the guidelines was changed to say from persons other than parties to the proceedings, and that case is no longer controlling. What the court doesn't address is the prefatory clause that says includes but is not limited to. Well, that includes but not limited to language is important. It's important because we have cases where we charge folks with income from several non-listed sources of income. For instance, we've got things like company cars, we've got forgiven rent. I think maybe the takeaway from this case is that we always need to consider any benefit that is being received by a party, not just those that are in the list. And we've got some Supreme Court cases here recently that say that the includes but not limited to language is an expanding clause. It's not a contracting clause. So you don't want to overlook those things. Now, K.O. is going to discuss this case later in much further detail when he gets into the next part, which is the Tennessee Family Law Update for 2013.